Law here at Duke, and welcome to the second in our fall Lessons Learned series. This series looks back at the way different issues have been, that have significant impact on public law and public policy have been addressed during the current administration, paralleling a similar exercise that the program did at the end of the Clinton administration. The topic today is science, which has become increasingly significant in all kinds of public law decision-making. Disputes about what constitutes good science have surrounded topics ranging from climate change to stem cell research to air quality standards to interrogation procedures. How much should science drive public decision-making in comparison with other public values such as human dignity and equity? How do we design institutions to deliver the best available science to decision makers in a timely fashion? All these questions and more have been debated and discussed in the past 8 years, and these debates will certainly continue. Today we have one of the best people in the legal academy to discuss these topics with us. He's Sid Shapiro from Wake Forest University, where he's a distinguished university professor and one of the nation's leading experts on regulatory policy, administrative law, and public law subjects generally. He's written 6 books and over 50 articles, numerous chapters in other books. He's been a consultant to government agencies, testified before Congress on regulatory policy and the role of science. He's currently the vice president of the Center for Progressive Regulation, a nonprofit organization of which I'm also a member. Before coming to Wake Forest, Sid was for years at the University of Kansas, where my sister still teaches, and that connection was how Sid and I first came to meet. We've been colleagues for a long time and have just collaborated on an article ourselves on a topic not unrelated to this one. So with that disclosure of personal bias out of the way, let me ask you to join me in welcoming Sid as our speaker this afternoon.
Yes, please. Thank you, Chris. I'm very happy to be here. I've received the usual warm hospitality from the faculty here. I do have one nit to pick, Chris. I was asked to send over a high-resolution picture so I could be put on a poster. So I really was looking forward to this. Have you seen the poster? President Bush is this tall. I'm down in the corner. On April 23rd, the Union of Concerned Scientists, a non-governmental organization in Washington, D.C., released a survey it had conducted of scientists who work for the Environmental Protection Agency. The survey found that almost 900 of the 1,600 scientists who work for EPA had experienced political interference in their work over the last 5 years. Scientists at 3 other agencies also reported political interference in their work to the union. The other agencies were FDA, which regulates the safety of pharmaceutical foods and drugs, the Fish and Wildlife Service, which protects wild animals and their habitats, and NOAA, which among other duties studies climate change. One of the primary ways that the Bush administration has politicized science has been to change scientific results or repress them. Perhaps the most notorious example involves Philip Cooney, who you see pictured, who was in charge of the White House Council on Environmental Quality until the year 2005. Prior to becoming a government official, he worked for various oil companies. Cooney edited scientific reports to overemphasize the scientific uncertainty of global climate change, the scientific uncertainty of the human role in global climate change, and to de-emphasize the scientific evidence of such a role. Officials at other agencies have also been asked or demanded that they change their risk assessments because the results did not support policy outcomes preferred by the administration. In other instances, the administration has refused to permit agency scientists to publish scientific papers or make presentations at meetings in order to suppress inconvenient scientific information. The administration has also engaged in science denial. The most obvious example is its obsessive refusal to acknowledge or act on the overwhelming scientific evidence of global climate change, but that's hardly the only example. FDA, for example, refused to approve Plan B, an emergency contraceptive, despite the fact that 2 scientific advisory committees had overwhelmingly found the drug was safe and effective. In light of the advisory committee recommendations, FDA's weak efforts to justify the outcome strongly suggest the administration was supporting the reproductive agenda of its religious supporters. These attacks on the integrity of science have not gone unnoticed. According to one author, the degree of lying, deception, and manipulation of information reported across so many federal agencies would seem to have required in the administration of George W. Bush a combination of callousness, mendacity, and hubris that is rare even in the messy history of American politics. The American scientific community agrees. More than 12,000 scientists, including 52 Nobel laureates, have signed a statement denouncing political interference with science in government and calling for reform. Today, I want to talk about the administrative process that's used in the United States to minimize political interference of this type. I will describe the institutional arrangements that are used to reduce the influence of politics in regulatory decision-making and assess the accomplishment of these arrangements. I will then return to politicization of science in the Bush administration and speak about lessons learned. I know I pressed something. Aha, good. Administrative agencies in the government date back to the founding of our country. The origin of the modern administrative agency, however, dates back to the 1880s and reflects the influence of the progressives. It was the progressives who introduced the idea that regulatory decisions should be made by persons with scientific and professional training. The progressives objected to business monopolies, unscrupulous corporations, and corrupt politicians that were prominent in the United States during the 1880s. The movement, therefore, supported the establishment of government agencies to regulate corporations and monopolies, but the progressives worried that these very agencies would be captured by the same forces. They therefore supported establishment of a civil service system of hiring and promoting government employees based on qualifications and job performance instead of political patronage. More generally, the progressive political movement supported expertise as a solution to political corruption. The progressives' faith in expertise was influenced by the development of scientific rationalism that was occurring at the time. This rationalism proposed human and organizational behavior was the product of relationships that could be rationally deduced and described by empirical and objective inquiry. The progressives therefore understood science to be a non-political and impartial methodology that would insulate government from undesirable political activity. The idea that expertise is a way of reducing political interference in the administrative process remains a foundational idea today. But it's also clear the progressives were mistaken that a professionalized bureaucracy was sufficient in and of itself to ensure good and accountable government. One reason is that administrators who run regulatory agencies may not follow the advice they are given by scientists. The other reason is that science cannot provide definitive answers to the important questions that regulatory agencies must resolve in order to regulate. The political appointee in charge of an agency may choose not to follow the advice of professionals working for the agency because following the advice conflicts with some personal motive, such as advancing his or her career by pleasing a political constituency of the president. Public choice theory, the dominant explanation of government behavior in political science and economics, expressly predicts such outcomes. This approach considers administrators not as government officials primarily concerned with the public interest, but as private individuals who seek to maximize their own utility. Just as businessmen and women would seek to maximize profit, public officials act to accumulate power, prestige, and other advantages that are in their self-interest. The administrator, therefore, will supply regulatory outcomes that favor the interest groups in the best position to support the person's ambitions. These are often the very business firms that the agency is supposed to regulate, because such firms find it more profitable to organize politically to support their self-interest than members of the public or the groups that represent the public. As I will develop, the public choice description of administration is incomplete and sometimes misleading. But these qualifications do not mean that agencies will not be captured in the manner that the theory predicts. Jeffrey Homestead, who was appointed by President Bush to head EPA's Office of Air and Radiation, is a good example. Homestead came to EPA from the law firm of Latham & Watkins, where, among other clients, he represented the Alliance for Constructive Air Policy, an electrical utility trade group whose goal it was to weaken the Clean Air Act. As the St. Louis Post-Dispatch has reported, Homestead helped, quote, craft new standards for mercury emissions from coal-fired power plants. As the rules were being written, career EPA staff employees were told by Homestead not to carry out the usual scientific and economic reviews. Worse, perhaps, quote, key passages in the new standards were copied word for word from memos prepared by the Washington lobbying firm of Latham & Watkins, where, of course, he used to work. Homestead also testified before Congress that EPA officials did not believe that proposed changes to a regulatory program called New Source Review, quote, could seriously undermine the EPA's lawsuits against violators of the Clean Air Act, when in fact his staff had warned him that such changes would have precisely this effect. I understand that claims of capture may be in the eye of the beholder. After all, what appears to be capture to an environmental group may just be sensible policy in the eyes of the chemical industry. Nevertheless, when an administration ignores scientific evidence or seeks to alter such evidence in order to reach a decision favorable to a regulated entity, it's a reasonable inference the administration is acting in a manner that public choice theory predicts. As polling data from the Union of Concerned Scientists indicates, this form of capture was routine in the Bush administration. Science can inform decision-making in useful ways, which is why scientists have been so concerned about the anti-science attitudes of the Bush administration. Nevertheless, many regulatory issues are trans-scientific, which means that although they can be stated as scientific questions, they are not capable of being resolved because of the state of scientific knowledge or because of the lack of accessible data. The assessment of dangerous chemicals offers a good illustration of this limitation. In the environmental statutes, Congress has established a risk trigger, which indicates when a risk is significant enough that it requires regulation. A typical formulation is that an agency is required to regulate if a risk exceeds some threshold defined to allow an agency to act on the basis of anticipated harm. EPA, for example, is required to regulate under the Clean Air Act when sources of pollution may cause or contribute to air pollution which may reasonably be anticipated to endanger the public health or welfare. In making such a determination, agencies seldom have conclusive evidence of the risks posed by chemicals. As the National Academy of Sciences has explained, data may be incomplete, and there is often great uncertainty in estimates of the types, probability, and magnitude of health effects associated with a chemical agent, and of the extent of current and possible human exposures. These problems have no immediate solutions, end quote. The lack of definitive evidence does not mean that regulation is inappropriate. Congress has required agencies to regulate on the basis of potential risk to humans rather than waiting for definitive evidence that a substance is harmful. This precautionary stance is reflected in the risk triggers. The triggers anticipate agencies will regulate on the basis of anticipated harms, such as the Clean Air Act provision, which I read a moment ago. In order to determine, then, whether incomplete scientific information is sufficient to meet the requirements of a risk trigger, agencies employ certain assumptions to overcome problems in their lack of data. These methodologies reflect scientific knowledge, but they're not purely the result of expertise. They also reflect policy preferences. For example, agencies like EPA typically assume, in the absence of evidence to the contrary, that a carcinogen has no threshold concentration below which the substance poses no risk of causing cancer. While this assumption is based on general scientific knowledge about cancer, agencies employ it because it's consistent with a statutory mandate to act on the basis of anticipated harm. The assumption serves a precautionary purpose because it errs on the side of the government overestimating the extent of harm rather than underestimating it. The trans-scientific nature of regulatory issues does not mean that science is not useful in resolving such issues, but the degree of assistance will vary. Scientific knowledge and evidence point the direction the agency needs to go. If the agency is operating on the frontiers of science, science will offer the agency less direction than if more is known. Decisions about risk, therefore, require science, but we don't rely solely on scientific expertise to ensure the accountability of regulatory agencies. As stated, administrators may ignore the science, and in any case, science cannot provide definitive answers to important questions that agencies must resolve in order to regulate. Since 1947, the country has relied on the legal procedures mandated by the Administrative Procedure Act to offer another layer of protection against the misuse of government power. Legal procedures work to ensure an agency's compliance with the statutory mandate first by reinforcing the role of scientific expertise. The courts review agency decisions on the basis of records compiled by the agency. The records are a compilation of the scientific, economic, and other types of evidence relevant to the agency's regulatory decision. In order to comply with the APA, the courts expect agencies to have sufficient evidence to support the rationality of a policy decision. Agencies cannot merely assert that an outcome is consistent with their mission. They must back up this assertion with data and expert opinion. In determining whether the evidence is sufficient, judges will also consider contradictory evidence offered by regulatory beneficiaries and regulated entities. More broadly, and second, legal procedures work to ensure that an agency's compliance with its statutory mandate. More broadly, legal procedures, try it again, work to ensure that an agency's compliance with its mandate by looking and matching the agency's policy decisions as compared to that mandate. I noted earlier that public choice theory and its prediction of agency capture is sometimes misleading. One reason suggested in a recent book by Professor Stephen Crowley of Michigan is that it fails to credit administrative procedures for deterring self-serving decisions by administrators. Crowley documents a number of regulatory decisions that adopt regulations over the objections of regulated entities, which contradicts the public choice prediction that agencies are doomed to be captured by the very entities they regulate. As Crowley notes, however, legal procedures do not guarantee that agencies are never captured. For example, the courts may have difficulty determining if an agency is acting consistently with its statutory mission when Congress states that mission in vague and general terms. The courts also have difficulty policing the lack of action by an agency, which can result from the capture of that agency by regulated entities opposing regulation. This has been particularly a problem in the Bush administration, which has been a reluctant regulator, to say the least. When such gaps exist, there's room for the politicization of science to occur. There's another problem, even more intractable. The federal judiciary is not elected, of course. Judges are appointed, and once appointed, they have lifetime tenure. This combination creates the potential for unelected judges to substitute their ideas about regulatory policy for solutions preferred by regulatory agencies. Indeed, there's persuasive evidence that this has occurred. A number of empirical studies correlate the outcome of a case with whether a judge has been appointed by a Republican or a Democratic president. That used as a proxy for ideology. The results demonstrate that a judge's ideology is a reliable predictor of the outcome of a case. For example, Dean Revesz has found that challengers seeking more stringent health and safety regulations prevailed in 50.3% of the cases, which involved at least 2 judges appointed by a Democratic president. The same side prevailed in only 27.8% of the cases before panels in which at least 2 of the judges were appointed by Republican presidents. Several other studies have reached consistent results. This politicization of judicial review is a topic for another day. It's enough now to observe that this may weaken agency accountability for the misuse of science. So, to sum up, the regulatory system is based on the 2 underlying conceptions of controlling agency discretion. First, to some extent, it trusts in scientific expertise. We expect that agencies will use their expert judgment, and to the extent this happens, courts will defer to that judgment. At the same time, we don't trust expertise entirely. Courts review regulations in recognition that agencies may ignore science, and in any case, regulatory decisions are not purely based on science. With this background in mind, we can return to the actions of the Bush administration, which have been so troubling. First, as noted, members of the administration have sought to change or alter scientific results. This effort is an attack on the integrity of a fundamental protection against the misuse of regulatory power. One of the ways the courts identify corruptive political interference is to ask whether the agency's decision makes sense in light of the evidence in the rulemaking record. If agency officials change that evidence to accord with their political preferences, this safeguard may not work. Second, members of the Bush administration have engaged in science denial, as stated earlier. The administration's refusal to act regarding global climate change is probably the best example of this head in the sand attitude. The judicial system, however, is not very good, as I noted earlier, against policing this lack of action. In this manner, the administration's disregard of science will have had the impact of delaying necessary regulation by several and perhaps years. So, as we move forward, what, if anything, can be done to discourage the type of politicization of science that has occurred? The best thing, of course, is for political officials to respect and take into serious consideration what science has to teach us. This is not only the right thing to do, it obviously avoids the problem of politicization of science. Whether such consideration can be mandated or at least encouraged by the use of administrative procedures is a pressing and difficult issue. I have two proposals. First, when Congress created OSHA, it created a science agency to assist OSHA, the National Institute of Occupational Safety and Health, or NIOSH. Congress located NIOSH not in the Department of Labor, where you find OSHA, but in the Department of Health and Human Services because it wanted to protect the scientific advice issued by NIOSH from political interference. This solution has one important difficulty. It creates coordination problems. Scientists in an independent agency will not necessarily work in accordance with OSHA's priorities. There may be another way to protect the integrity of scientific advice. Congress could require that an agency publish scientific documents without editing or change by agency officials. Under the Freedom of Information Act, there is an exemption for interagency memoranda which would not be available by law to a party other than by a party with whom the agency is in litigation. The legislative history makes it clear the exemption was intended to incorporate the government's common law privilege from discovery and litigation. According to the Supreme Court, this privilege includes executive privilege material or pre-decisional documents. The reason for the privilege and the FOIA exception, as you would suppose, is to protect open and frank advice and recommendations from government employees to their bosses. Under the FOIA exception, scientific advice and reports from agency staff to agency officials is generally not available to the public because it falls within the ambit of pre-decisional documents. This secrecy, however, facilitates the politicization of science. Under a veil of secrecy, agency officials have greater leeway to change scientific documents or ignore them. I would therefore urge Congress to consider eliminating the FOIA exception as it applies to certain categories of scientific documents, and to require instead that such documents be made public as they are finished and before they are submitted to the political officials of the agency. The argument against this proposal, of course, is that it will interfere with agency officials receiving the fullest and most candid advice. I don't think this objection applies to this situation, however. The advice being received in the documents I would cover is about the state of science and not about what action the agency ought to take based on the state of science. Thus, although the information is relevant to the agency's decision, it's not an advice or recommendation concerning that decision. So it doesn't fall within the full ambit of a pre-decisional document. Will it work? I don't know, but those are my ideas. I'm done and I can take questions.
Question. Yeah, it's more of a political question, I think, than a legal one. But do you have any sense that prior to the Bush administration, we saw this kind of political intrusion on a regular basis? That it appears to be the case in this particular case.
No, the Bush administration, I think everybody would agree, stands out in this regard. That's quite consistent with the way they have taken office and sort of asserted the prerogatives of the president and his particular policy preferences across the board, as we know. They've been hard charging. And the general difficulty and the brilliance of this strategy is the system will calibrate and head off some of this, whether it's concerning fighting a war or politicizing science. But it takes a long time for the system to catch up. For example, if judicial review works and it actually catches the administration in one of its science manipulations, that's good, right? Because we've caught them. But the outcome is then we have to go back and start the policy process over again. And 4, 5, 7, or 8 years will have passed with nothing being done about the particular problem which they've politicized. So it's a wonderful strategy. And if you are a regulated entity, you then have the benefit of those 4, 5, 6, or 7 years of no action, which is a very profitable position for you as a regulated entity to be in. Please.
Can we assume that these agencies are politically neutral? I know for oftentimes there'll only be one agency, and if that has any sort of political leanings one way or the other, do we really get a full picture of what's going on in the real world?
That's a really good question. So the question is, okay, we know that presidential appointees are political. That's the whole purpose of appointing them. The president appoints political appointees. By the way, the Bush administration has more political appointees in the agencies than any administration prior to it. So they've sent more of their forces into the agencies to carry out this very aggressive agenda than previously. But what about the agency itself, which is the people who work there, who by and large are hired because of their expertise? So we're really back to this sort of progressive notion. If we hire people who are professionally trained as scientists, as economists, as lawyers, and that's the purpose for which they're hired, can we really trust them to be non-politicized? Or will they also just fall into this kind of ideological mode? I think we can. I think the progressives were onto something. And we've lost sight of this, in part because, and for two reasons. We've lost sight of the possibility that a professional bureaucracy is a bulwark against politicization for two reasons. First, every politician runs against the bureaucracy. No one likes the bureaucracy, and our legislators, our presidential candidates, for the most part, are very quick to exploit that. So we've sort of denigrated the idea of public service. So it's not exactly attractive, if it ever has been, to go into government with your expertise. Secondly, lots of good folks have left, particularly in the last 8 years. The scientific staffs in particular and the other professional staffs of these agencies have just left because nothing could be done. They were demoralized, so on and so forth. Nevertheless, I do believe, and sociology teaches, that when we grow up in a profession, like the legal profession, we really have some expectation as to what the proper sort of relatively neutral way of analyzing a problem is. And if others hold us up to that expectation, we will then act in, I think, a more impartial fashion. Let me give you an example. Many years ago, because I'm old, I worked for the Federal Trade Commission right at the end of the Nixon administration and into the Ford administration. And, you know, there was a fairly politicized presidency. And my boss, the head of the antitrust division, came over from one of these Washington law firms, not Latham and Watkins, but one of them. But The difference then was that he knew that his job performance would be measured by how good an antitrust prosecutor he was, how good a lawyer he was. That was the expectation in Washington, that he wanted to prove himself to be a very good, aggressive lawyer on behalf of his client, the FTC. And that was the way that one got a better job. That's the way that one impressed his or her peers. Well, what has happened since? Well, we've got the Federalist Society on one side, we've got the American Constitutional Society on the other, and now the expectation is we need to train lawyers to serve ideological interests. And to some extent, although I belong to ACS, I'm troubled by that. I think we need instead to try to reestablish this notion of impartiality. If not in law, certainly in science. And we may stand a better chance there. It's certainly more objective than law. But I think we need to start judging each other by how well we do representing the client rather than the interest or ideology. Long answer, sorry.
With respect to the Freedom of Information Act reforms, many states have much more robust freedom of information laws than the federal government at this point. Can you think of any that stand out that have sort of rolled back some of these ideas of executive and deliberative process privilege, and is there any evidence that that is actually inhibiting the values that the Supreme Court said were behind that privilege?
I don't know of any examples in the states, and I'm sure this will be considered a very radical notion, the notion that you release any document before it's done, the agency's done, seems fairly radical. The FOIA exemption itself is discretionary. All but one of the Freedom of Information Act exemptions are discretionary. So when Congress passed FOIA, the baseline is all government information is public unless it fits within one of the exemptions. And then even if it fits within one of the exemptions, an agency is still free to release it, which seems to me to lean more towards my proposal than not. However, assuming I get the votes, I wouldn't leave it to an agency to do this voluntarily because the pendulum can swing back and forth, and attitudes about FOIA tend to differ in Republican administrations and Democratic administrations, with the latter being tilted a little more towards disclosure. So I think it's a kind of reform that Congress would have to enact and enforce. Yes, please.
Back in the, I think it's 1970s, when a lot of states were passing their own public records laws, and Florida at the time had a fairly progressive government, and one of the rationales there was that deliberative documents should be public. So
thank you.
The public, and it was kind of a movement that I think was pushed by some of the journals and schools and some of the universities at the time.
I appreciate that. Hold on, I got to write this down. Okay. Yes, please.
Another FOIA comment. I would just push you to be even a little more radical. I mean, FOIA is a pre-internet era statute. And so if the default is that documents should be public, instead of demanding the request as an additional step, it might be interesting to identify certain documents which should be automatically released even without a request trigger. And
yes.
Since I don't know about, okay.
I think that follows absolutely. FOIA is kind of a funny thing. You got to ask for the documents. And even if they're not covered by deliberative privilege, if they're just sitting there, it doesn't do anyone any good anyway. So you're absolutely correct, of course, that given the internet is sort of infinity or something close, we got plenty of room to put these documents up there. Please.
To Jonathan Weiner.
Oh, yeah. I can't see the back of the room.
I hear you making both a descriptive account and a normative proposal, or two proposals. I want to ask you about each of those. On the descriptive account, I certainly agree with you about climate change and some other issues. But I wonder, thinking more broadly and historically, how do you account, or how does your story take account of counterexamples like the Clean Air Interstate Rule, in which the Bush administration, the current Bush administration, perhaps surprisingly, adopted very aggressive air pollution control regulation, and it was actually the same official you mentioned, Jeff Olmstead, who was the lead official on that. Or thinking historically, other counterexamples in which science has been at issue in prior administrations or embedded in the agency decision-making, but not coming necessarily from an overt presidential political level. And there have been many examples of judicial review in which the courts have questioned agency science in past administrations. I'm thinking, for example, of the leather industry's decision by the DC Circuit in which Judge Pat Wald, no conservative, Democratic appointee, found that the science underlying EPA's rules on sewage sludge were absurd because EPA had assumed that infant children would sit on highway median strips consuming sewage sludge 250 days per year. So those examples also occur. And how one of the critiques by another perspective, not necessarily my perspective, but has been that that there's misuse of science built into agency risk assessments, and that's what they were trying to correct. Although I think I would agree with you that the way this administration has handled it has not been the correction. So then the normative proposal question is these independent science agencies. How effective are they really? Is there evidence that NIOSH has been more successful? The NIOSH-OSHA relationship has been more successful than the internal science relationship at, say, at EPA or at the Food and Drug Administration, or looking at Europe, where Europe has it has a separate cabinet department for science and research, DG Research, and it also then has separate science agencies for food safety and for environment, some others. And it'd be interesting to see how effective those have been. The most prominent recent decision of the European courts reviewing science in that relationship in the European Union system was one in which European regulators banned antibiotics in animal feed. In one case, at odds with their scientific body's advice not to adopt the ban, and in the other case, not consulting the scientific body, which the European statute said they had to. And the court said, well, that's okay. It's really up to the regulatory agency to decide what information it's taking, which would seem to be the opposite of your proposal. So how do these independent scientific bodies really function? Are they really more successful?
Okay, so there's 17 questions there. Now I know how you all feel in class. Answer this, answer that. I mean, to be flippant, I was asked to talk about the Bush administration, so I didn't reach too far back. But is this the only administration that's engaged in politicization of science? Of course not. Has it always engaged in politicization of science? No. It's a question of degree here. And so then you get into the, example, counterexample, example, counterexample. I guess I would just rest on the perception of the scientific community, which could be wrong, but this is the first time I'm aware of that 12,000 scientists have signed a petition protesting the administration's use of science, which suggests that this is something different and above, as a descriptive manner, a normal level of activity. I think you raise a fascinating question about whether independent scientific agencies are an answer at all, and perhaps not. When I first wrote this talk, I basically rested with the proposition there's only so much one can do to end politicization of science, and maybe the answer ultimately is back to the ballot box, that we have to elect presidents and administrations that honor science a little better than this one has. Nevertheless, I think it's worth looking at these examples and trying to determine whether this is a way to go. As Professor Weiner knows, the EU agency was set up in response to a politicization of science, the mad cow disease brouhaha in the EU, where Great Britain in particular and France to a lesser extent was able to pressure regulators to ignore some of the information that was coming out, and that was sort of buried for a while, and the general consensus was they didn't act as quickly as they could have had that not occurred, which led them to take the leap of faith, if you will, to an independent agency. So I accept the suggestion. I think it's a good one that we ought to go back and look at what's happened over at NIOSH over these years, what's happened in the Bush administration in NIOSH, which I have not studied, and use Europe as a possible model to learn more. Those are all, I think, really good, constructive suggestions. Please.
I'm coming from the science perspective, and I have two comments. One is regarding FOIA. I mean, if a bunch of agency scientists are passing a draft document between each other, their conclusions could change during that just based on science. And you wouldn't really want to have an old, early draft you don't support brought back, up to you and have to, try to defend. The second comment is, you talked about the interference in things like EPA, sort of regulatory science body. Do you have examples of interference in, say, National Science Foundation and National Institute of Health, things that, promote academic science?
Let me take the questions in order. There is a question of timing here, and it may not be soluble, I don't know. But you're absolutely right, scientific documents change as they go forward. I assume at some point it comes to a rest, and there is a definitive document for at least that point in time which could be released. The fact that that document may also change doesn't bother me at all. Let's just put the next document up online and have that one up as well. So I agree with you, we don't want to do it too early, but at some point it seems to me, at least as a theoretical matter, there should be a point at which we could say the scientists in the agency are about to send this into the agency decision making. That's the time where we would put this thing up. No, I think NIH has largely escaped this process. It's interesting to speculate why, and maybe this feeds back into what I was saying. The whole process is so involved with peer review, that is the granting process where scientists are themselves making the decisions about scientific applications, and that those are really pretty much final. And so it seems to me the scientists have more control of their destiny and of their decisions in that kind of decision-making process than they do over an EPA, say. Please.
So if the decision about how much to regulate is kind of one of policy, and you hear that with security markets right now, like, I guess why should we expect science to be treated differently? I mean, is it just that the statutes, like the FDCA or whatever, tells them they have to use science, or is it something deeper about science?
Well, on the one hand, I think we want to do the best possible decision making we can, so we have to look at the science. We would be silly not to. The question of where the science ends and policy begins is actually a fairly hard question. And there are some questions, some issues which are purely scientific, some which are purely policy, but the two sort of bump up in a gray area in the middle. And that's often very hard to untangle. And so it is the case that science can leak over into policy and policy can leak over into science. And that's one of the complications I suppose we just have to live with. The actual mandate that science be considered, besides just being a good idea, I think is implicit in most of these statutes, and the courts would expect to see this evidence anyway. So everyone does science in the regulatory mode.
Let me just say that the series is being is a collaborative effort between the Program on Public Law and the Constitutional Law and Policy Journal, which will be posting all of these lectures. As I say, SIDS is the second. The third in the series is October 22nd Goodwin Liu from University of California, Berkeley will be speaking on the topic of civil rights. So have a great fall break and come back on the 22nd to talk about civil rights. Thank you very much, and thanks to Sid.